For the felicitation, we have Advocate Pallichal S.K. Pramod, Member, Bar Council of Kerala. I welcome you, sir.
Honorable Justice Shobha Annama Matthew, Bhuvanayatulla Justice Judge, Member, Secretary KeLSE, Sri Nisar Ahmed, Advocate Shrimati Indira Govindran, Dr. Gifty Woman, Advocate Rose Mariam, Adakamulla Priyapetta, Nebaringate Adhyavagare, Nebanyare. തീർച്ചയായും ഈ ഫെലിസിറ്റേഷനോട് കൂടി ഇതിന്റെ ആ ഒരു ഇനാഗുറൽ സെഷൻ അവസാനിക്കുമെന്നാണ് ഞാൻ മനസ്സിലാക്കുന്നത്. ചർച്ച ചെയ്യുന്നതിന് വേണ്ടി എടുത്തിട്ടുള്ള ഈ നിയമം 1997 ബഹുമാനപ്പെട്ട സുപ്രീം കോടതിയുടെ കേസിന് ആസ്പദമായി വന്നിട്ടുള്ള നിയമം. അതിനു മുമ്പ് 1948 യൂണിവേഴ്സൽ ഡിക്ലറേഷൻ ഓഫ് ഹ്യൂമൻ റൈറ്റ്സുമായി ബന്ധപ്പെട്ട് UN കൺവെൻഷനോട് കൂടി ലോകത്ത് തന്നെയുള്ള വൾണറബിൾ സെക്ഷനിൽ കുട്ടികളും സ്ത്രീകളെയും ഉൾപ്പെടുത്തി അവരെ സംരക്ഷിക്കുന്നതിന് ആവശ്യമായിട്ടുള്ള നിയമനിർമ്മാണങ്ങൾ ഉണ്ടാകണമെന്നുള്ള ആഗോളതലത്തിലുള്ള നിർദ്ദേശം നൽകിയിട്ടുണ്ട്. 1987 രണ്ടാമത്തെ കൺവെൻഷനോട് കൂടിയാണ് സജീവമായി ലോകരാഷ്ട്രങ്ങളാകെ തന്നെ ചർച്ച ചെയ്യപ്പെടുന്നത്. പക്ഷെ ഇന്ത്യയിൽ 97 ഇതിന്റെ ആവശ്യകതയെ സംബന്ധിച്ച് സുപ്രീം കോടതിക്ക് മുമ്പ് ഒരു കേസുമായി ബന്ധപ്പെട്ട് വന്ന കാര്യമെല്ലാം ആ കേസിന്റെ ക്രിമിനൽ സ്വഭാവത്തെ സംബന്ധിച്ചും ആ ക്രൈം കേസിനെ സംബന്ധിച്ചും ഉണ്ടായിട്ടുള്ള വേർഡിക്റ്റും എല്ലാവർക്കും. പക്ഷെ എന്നാൽ രാജ്യത്തെ സുപ്രീം കോടതി അക്കാര്യത്തിൽ വളരെ വ്യക്തമായ നിർദ്ദേശങ്ങൾ നൽകിയിട്ടുണ്ടായി. ഏതാണ്ട് പിന്നെയും ഇവിടെ നമ്മുടെ ജസ്റ്റിസ് ചൂണ്ടിക്കാണിച്ചതുപോലെ തന്നെ അത് അഡ്രസ് ചെയ്യുന്നതിന് വേണ്ടി ഒരു നിയമം ഉണ്ടാക്കുന്നതിന് വന്നിട്ടുള്ളൊരു കാലതാമസമാണ് അതിന് ഏറ്റവും ഗൗരവതരമായിട്ടുള്ളത്. 97 സുപ്രീം കോടതി അത്തരത്തിൽ പറയുന്നതിന് ശേഷവും 2013 വരെ നിയമമായി മാറുന്നതിനുള്ള കാലതാമസം എന്ന് പറയുന്നത് വളരെ ഗൗരവതരമുണ്ടായി, പ്രത്യേകിച്ച് ഇന്ത്യ പോലുള്ള പ്രധാനപ്പെട്ട ഒരു രാജ്യം. തീർച്ചയായും ഈ നിയമത്തെ സംബന്ധിച്ച് ചർച്ച ചെയ്യുമ്പോൾ അതിനകത്തുള്ള ചില പോരായ്മകളൊക്കെ വളരെ രൂപത്തിൽ ഇപ്പോ ഇന്ദിരാ രവീന്ദ്രൻ മാഡം അത് സൂചിപ്പിക്കുകയുണ്ട്. പ്രായോഗിക വശങ്ങളെ സംബന്ധിച്ച് ഇപ്പോഴും ഇത് നടപ്പാക്കേണ്ടവർക്ക് ബോധ്യമില്ല എന്നുള്ളത് നിയമം നടപ്പാക്കുന്നതിൽ ഉണ്ടാകുന്ന മറ്റൊരു ബുദ്ധിമുട്ടാണ്. ഇപ്പോ ഇന്റേണൽ കമ്മിറ്റി ഉണ്ടാവണം, അല്ലെങ്കിൽ കംപ്ലൈൻസ് കമ്മിറ്റി ഉണ്ടാവണം, അതെങ്ങനെ ഫോം ചെയ്യണം, അതിനെ സംബന്ധിച്ചുള്ള നടപടിക്രമങ്ങൾ ഇവയൊന്നും അല്ലെങ്കിൽ തന്നെ ഇതിന്റെ ഇരയായി വരുവാൻ സാധ്യതയുള്ളവർക്ക് പോലും അവരുടെ അവകാശങ്ങളെ സംബന്ധിച്ച് അറിയാതിരിക്കും. തീർച്ചയായും ഇവിടെയാണ് KeLSE പോലുള്ള അല്ലെങ്കിൽ നമ്മുടെ LJRF പോലുള്ള സംഘടനകളുടെ പ്രത്യേകമായിട്ടുള്ള പങ്ക്. ഇത്തരം ചർച്ചകൾ അതിന് ഉപയോഗപ്രദമാകുമെന്നാണ് ഞാൻ മനസ്സിലാക്കുന്നത്. എനിക്കൊരു നിർദ്ദേശമായി ഈ ചർച്ചയ്ക്ക് ആധാരമായിട്ട്, ചർച്ചയാണ് ഇക്കാര്യത്തിലെ പാനൽ ഡിസ്കഷനാണ് ഇതിന്റെ ഏറ്റവും ക്രക്സ് ആയിട്ടുള്ളത് എന്നുള്ളത് എനിക്കറിയാം. അതുകൊണ്ട് കൂടുതൽ സമയം എടുത്ത് പോകാൻ ഞാൻ ആഗ്രഹിക്കുന്നില്ല. ഒന്നിപ്പോ ഈ ഇന്റേണൽ കമ്മിറ്റിയെ സംബന്ധിച്ച് ഇപ്പോഴും പല സ്ഥാപനങ്ങളും അല്ലെങ്കിൽ ഇത് നിർബന്ധമായും വരേണ്ട സ്ഥലങ്ങളിൽ ഇത് വന്നിട്ടില്ല എന്നുള്ളതാണ്. ഒരു മേഖലയിൽ നമുക്കിപ്പോ മുനിസിപ്പൽ ലോസ് നമ്മുടെ നാട്ടിലുണ്ട്, അതായത് നമ്മുടെ പഞ്ചായത്ത് രാജ് ആക്ടും മുനിസിപ്പാലിറ്റീസ് ആക്ടും. വർക്ക് പ്ലേസിനെ സംബന്ധിച്ചിട്ടുള്ള അനുവാദം അവരുടെ ലോക്കൽ അതോറിറ്റിയുടെ നിർബന്ധമാണ്. അപ്പൊ ആ വർഷാവർഷം ആ ലൈസൻസ് കൊടുക്കണം. സ്വാഭാവികമായും നമുക്ക് വേണമെങ്കിൽ ഒരു നിർദ്ദേശമായി കൊടുക്കാം. ഈ DNO ലൈസൻസ് കൊടുക്കുന്ന സമയത്ത് ഇത്തരത്തിലുള്ള ഇന്റേണൽ കമ്മിറ്റികൾ ഫോം ചെയ്തിട്ടുള്ളതിന്റെ കൂടി ഒരു അനുബന്ധമായി അനക്ഷറായി അതിൽ പ്ലേസ് ചെയ്യാൻ കഴിയും. അപ്പോൾ ആ ഒരു ലെവലിൽ, ഒരു ഗ്രാസ് റൂട്ട് ലെവലിലോ അല്ലെങ്കിൽ ഏറ്റവും താഴെ തന്നെ സ്ഥാപനം പ്രവർത്തിപ്പിക്കുന്നവർക്കും അവർക്ക് ഇത് ഉണ്ട് എന്ന് നമുക്ക് ഉറപ്പാക്കുവാൻ വേണ്ടി കഴിയുന്ന സാധ്യത. അത്തരം ചില കാര്യങ്ങൾ കൂടി നമുക്ക് ശ്രദ്ധിക്കാൻ കഴിയണം എന്നുള്ളതാണ് എനിക്ക് ഈ വന്ന ഈ ഫെലിസിറ്റേഷനാണ് എന്റെ നിശ്ചിതമായ കടമയെങ്കിൽ പോലും ഈ പാനൽ ഡിസ്കഷൻ, ഈ പാനലിന്റെ പാർട്ടിസിപ്പന്റ് ലിസ്റ്റ് നോക്കുമ്പോൾ നിയമരംഗത്തെയും അതുപോലെ നിയമ അധ്യാപക രംഗത്തെയും പ്രമുഖരായിട്ടുള്ള ഒട്ടേറെ പേരാണ് പങ്കെടുക്കുന്നത്. തീർച്ചയായും ഇന്നത്തെ ഈ ഡിസ്കഷൻ കൊണ്ട് ഈ നിയമവുമായി ബന്ധപ്പെട്ട അറ്റ്ലീസ്റ്റ് കേരളത്തിലെങ്കിലും നമുക്കൊരു നല്ല ഗൈഡ് ലൈൻസ് കൊടുക്കുന്നതിന് വേണ്ടി ബന്ധപ്പെട്ടവർക്ക് മുമ്പിൽ സമർപ്പിക്കുവാൻ കഴിയുന്ന വിധത്തിൽ നമുക്കിത് മാറ്റുവാൻ കഴിയും. അതിന് ഇത് ഉപകാരപ്രദമാകട്ടെ എന്ന് മാത്രം ആണ് എനിക്ക് ആശംസിക്കുവാനുള്ളത്. ഇതിന്റെ സംഘാടകരായി വന്നിട്ടുള്ള എല്ലാവരെയും, സമയക്കുറവ് കൊണ്ട് പാനൽ ഡിസ്കഷനിൽ കടക്കുവാനുള്ളത് കൊണ്ട് ഇതിന്റെ സംഘാടകരായി വന്നിട്ടുള്ള എല്ലാവരെയും, ഗവൺമെന്റ് ലോ കോളേജ് എറണാകുളം, KeLSE, അതുപോലെ നമ്മുടെ LJRF അടക്കമുള്ള ഫൗണ്ടേഷൻ അടക്കമുള്ളവരെയും ഇതിന് ഹാർദവമായി അഭിനന്ദിച്ചുകൊണ്ട് എന്നെ ക്ഷണിച്ചതിനുള്ള നന്ദിയും അറിയിച്ചുകൊണ്ട് ഞാൻ അവസാനിപ്പിക്കുന്നു. നിങ്ങൾക്ക്
Thank you so much, sir. That was indeed and heart-enriching words from you. Thank you so much for that. Now that we have come to an end of our first session, I invite Advocate Rosemary Sibi, convener, LJRF Center for Women and Children, to deliver the vote of thanks. I welcome you, ma'am.
Very good evening to one and all. We are extremely happy to see the presence of respected dignitaries and all the participants over here, since this topic is of much importance. I hope after listening to all the dignitaries, all the participants have become aware. Why did we select such a topic? What is the purpose behind selecting such a topic? The more discussion will be upcoming and the more things will be discussed, which will be fruitful and helpful in order to deal with the lacunas and all other problems faced by the POSH Act in our scenario. So without wasting much time, I would like to thank all the respected dignitaries, those who were inaugurated the session, those who were the participants of this inaugural session. First of all, I would like to thank Dr. Bindu M. Nambiar, Principal, Government Law College, Ernakulam, for presiding this session. We express our thankfulness on behalf of all the participants over here.
Thank you.
Next, Honorable Justice Shobha. Thank you, ma'am. Thank you so much. Next, Honorable Justice Shobha Annama Epan, Judge, High Court of Kerala. We consider her presence as so very precious, since she is such an experienced hand to deal with such a problem. So she was the apt person to inaugurate our session. We express our sincere gratitude from our heart on behalf of KeLSE and on behalf of Government Law College Ernakulam and LJRF Center for Women and Children, and on behalf of all the participants. Thank you so much, ma'am. Then Nisar Ahmed Keti, sir, District Judge and a Member Secretary of KeLSE. Sir, without you, this would not have been possible. I'm sure that this would not have been possible. Actually, you made this initiative a dream come true. We are really grateful to you for your support, and you expressed your support in your speech as well. We are really happy to have you here, sir. Thank you so much, sir. Then Advocate Indra Ravindran, ma'am. Ma'am has given an elaborated details regarding the practical implementation of this POSH Act. She's a member of Kerala Women's Commission, and her words are really thoughtful, and we express our thankfulness to you, ma'am. Thank you, ma'am. Then Dr. Gifty Woman, ma'am, Associate Professor of Government Law College, Ernakulam. Ma'am, actually your care and affection is really an inspiration for us to move on. Thank you so much, ma'am. Your words are so helpful for us to conduct such events. Thank you so much, ma'am. Then Advocate Pallikar S.K. Pramod, sir. Sir is a member secretary of Bar Council. Sir, your words were actually very much informative and thoughtful as well. Thank you so much, sir, for such a wonderful speech, as well as for being here. Thank you so much, sir. And I express thanks to all the invited guests and all other participants. And we are moving to the panel discussion right now, which is an eagerly awaiting session. Over to you, Uttara. Thank you once again.
Thank you so much, ma'am. That was indeed a heartfelt gratitude from your side. Thank you so much for that. Now that is a wrap to the first session of our panel discussion on the topic sexual harassment against women at workplace, conducted by Kerala Legal Services Authority in association with Government Law College Ernakulam and LJRF Center for Women and Children. By now, I conclude from the job assigned to me. Before I move on, I have to bring into the attention of the participants. If anybody is interested to be a resource person in LJRF Center for Women and Children, kindly contact with the conveners or the other associated people in LJRF. And to take on with the next session, I invite Ms. Aisha Rahmat, an inquisitive law student from Government Law College, Trivandrum. I welcome you, Aisha.
And respected dignitaries, teachers, faculty members, and all my dear friends. A very good evening to one and all present here. Before we move into our second session, I would like to make two announcements. Firstly, please ensure all your participation till the end of sessions, and certificates will be provided to all the participants, the link for which will be given at the end of the session. And moving on, secondly, just as Uttara now mentioned, if any of the students is interested to become a resource person for LJRF, please contact any of the conveners or the associated members of LJRF. Moving on, first, I cordially invite Advocate Reshma OP, convener of Webinar Committee LJRF Center for Women and Children, to deliver the welcome address. On to you, ma'am.
Good evening, one and all. American civil rights activist and poet Maya Angelou rightly said, each time a woman stands up for herself without knowing it, possibly without claiming it, she stands up for all women. A remark of great importance in the time women empowerment has gathered momentum. An equal world where everyone feels safe and secure is a foundation stone of prosperous society. Unfortunately, sexual harassment stood in the way of women and their dreams. Strong mechanism to correct and curb wrongs of society is necessary. The Sexual Harassment of Women at Workplace Prevention Redressal Prohibition Act 2030 is a right move in this regard. Today, we have a very decorated panel at very limited time. I would be wise of my cut the formal welcome speech and let the discussion start. Dr. Girishankar sir will control and steer this discussion to fruitful end. He is an associate professor at Government Law College, Ernakulam. And Honorable District Judge Sri Kamini sir is here with us to share his valuable insight on the subject. He presides the Special Court for CBI and NAA cases. An Assistant Director of Kerala Judicial Academy, Dr. John Varghese sir has honored us with his presence and will enlighten us with his wisdom. We are glad to hear Dr. Taji GV, Assistant Professor at Trivandrum Law College, and she is Advisory Committee member of National Women's Commission. And Dr. J.S. Joseph sir, Decorated Police Officer and Criminologist at Kerala Police Academy. On behalf of the committee, I cordially welcome all the panelists to this discussion with whole heart and eager ears. Your knowledge and wisdom will be shared in expectation of better change and brighten tomorrow. I once again welcome all the panel and audience to discussion. Thank you all.
Thank you for the heartwarming welcome, ma'am. Next, I introduce and invite the moderator for our session, Dr. S.S. Girishankar, Associate Professor, Government Law College, Ernakulam, to facilitate the gathering. On to you, sir.
Thank you, Aisha. Hope I'm audible.
Yes, sir, you're audible.
Yes. So good evening, all the dignitaries who have participated in the inaugural session. Honorable Judge Nizar Ahmad sir, Principal Government Law College Ernakulam, Senior Faculty Government Law College Ernakulam, and other persons who had participated in the inaugural session. The fellow panelists, distinguished resource persons, Sri Kamanish, Special Judge, CBI 2 NIA cases, Ernakulam, Dr. John Varghese, Assistant Director, Kerala Judicial Academy, Dr. Jayeshki Joseph, Criminologist, Kerala Police Academy, Dr. Taji CB, Assistant Professor, Government Law College, Trivandrum, and all other dignitaries, participants, colleagues, and dear students. This is a defining moment, not only for all the three organizers, namely the KeLSE, Government Law College Ernakulam, as well as the Center for Women and Children of the LJRF. This discussion should go a long way. This panel discussion should go a long way in deliberating on the various facets of a law which was brought into effect 8 years or 9 years back, and which has been brought to the fore to the discussion many a times, always being discussed in its various shapes. Obviously, when we talk about, as an introductory note, I'm reminded of the seminal contribution made by the Supreme Court, Honorable Supreme Court of India, when it used or utilized Article 142, which is the power to do complete justice, to come forward with a judicial legislation, which is being hailed as one of the finest judicial legislations with all the settings of a law, and which has been hailed across the jurisdictions, particularly to fill a legal vacuum. But I don't say that I may not be able to tell this august audience that it somehow happened in a stroke in 1997, but it was a long drawn matter that had invited the attention of the Honorable Supreme Court since decades. And if this august audience is reminded of Saheli versus Police Commissioner, Delhi Domestic Maid Servants Association cases, all those public interest litigations which have invited the attention of the Honorable Supreme Court towards a conspicuous legal vacuum, which had impacted adversely the labor market and also individuals, both organized in the organized as well as unorganized sectors of labor market. I think this was a well thought out measure on the part of the Honorable Supreme Court of India to go for a judicial legislation to aptly fill a legal vacuum which has got a bearing on preferred fundamental rights that is documented in Indian Constitution 14, 19, and 21, Articles 14, 19, and 21. So this was what I was trying to convey to you, was that this was an evolution. There was an evolution as far as the Vishaga guidelines was concerned. And as as Advocate Pallichal Pramod was stating, again it took another more than 15 years, or rather close to 15 years, or more than 15 years, 16 years in fact, for the Parliament to respond to the call from judiciary. Even when we speak highly about our commitment and solidarity in promoting dignity, the concept of dignity, which is a central issue as far as meaningful existence is concerned. So that is where, again, the lethargy that our system has got towards certain crucial issues become very, very relevant. And even after the enactment, it had presented so many, or it has been caught in so many controversies, and so many things have to be resolved. So that is why it is in the hot seat, or it is being continuously deliberated in the midst of the society. So without taking much of a time, I'm particularly honored and privileged to coordinate a bunch of resource persons, eminent resource persons, who may reflect upon the views of the Supreme Court, maybe in coming to that conclusion, that is in the judicial legislations, best practices and methods that could have been employed in this particular issue. Then the international perspectives, which had cascaded into the domestic level jurisprudence, India being a signatory to so many international conventions, and it was the international responsibility as far as India is concerned to translate all these international responsibilities to domestic legislations. So in that way, CEDAW and so many other conventions, and the practical difficulties that are being faced while the law is being implemented, the legal architecture that is being designed under this act, how it is being reckoned. So several host of issues, a bunch of issues are there. So I earnestly anticipate that our resource persons will be dealing on so many matters, including these matters that I've highlighted. It's my honor and privilege to welcome the resource persons for this day, Dr. Sri Kamanish K, Honorable Special Judge of the CBI2 dealing with NIA cases Ernakulam, Dr. John Varghese, Assistant Director, KGA Judicial Academy, Dr. Jayesh K. Joseph, Criminologist of the Kerala Police Academy, and Dr. Taji CB, Assistant Professor, Government Law College, Ernakulam, who is also the Advisory Committee member of the National Women's Commission. I would request our honorable resource persons to employ 12 to 12 to 13 minutes as part of your deliberation, so that you will get a reasonable time. I don't know whether it is reasonable, particularly talking on this topic having several societal ramifications. But still, as we have to respect the time frame, I would request you all to confine your deliberations within a space of 12 minutes so that we can have a wind-up session, and any responses to the deliberations of the resource persons, I would request the participants, I think you are properly intimated, that you can send an email to the honorable resource persons so that they can respond to your call regarding their deliberations. With these few words, it's my privilege and pleasure to invite Sri Kamlesh K, Special Judge, CBI 2 of Ernakulam, who's I had the opportunity to hear him on many occasions, and those speeches that he has delivered, particularly on various facets of gender equality, gender discrimination, gender justice, gender gap, so many things, which is available on YouTube. And sir, it's my privilege and honor to welcome you to deliberate on this topic, particularly on a forensic analysis of sexual harassment of women in workplace, prevention, prohibition, and redressal Act 2013. Thank you. Please.
Thank you very much, sir, for your kind words. Respected Nisar Ahmed, sir, I see my brother, Dr. John Verghese, Professor Taji, and all other respected persons and personalities. There are no concepts like on the dais or off the dais, so I address everybody. Well, as somebody hailing from the functional area, what I'm expected to tell you, this August audience, is probably what Professor Girishankar has right now suggested, a forensic analysis. So a forensic analysis from the side of a sitting judge may probably focus on the loopholes, probably the need of new legislation, newer amendments and all that. And there are basically certain misconceptions, and therefore, sir, I will be focusing more on the last 3 bullet points, which you have mentioned in your note. And sir, so with respect to the history and all behind this particular statute, see, much light has been thrown. And therefore, I do not think that there is any need for me to mention all those historical aspects down here. What I am intending to submit, intending to place before this August Assembly is basically this. See, here we have a statute which has created a new right which did not exist prior, at least in the legislative field. Of course, Vishaka guidelines had been there. Those had been judicial legislations, and therefore, on the stricter legislative sense, this right never existed. So it creates so you please look into section 3 of the Act, the Posh Act. It creates a new right. It prohibits sexual harassment in workplaces. This is just a simple sentence, but this is more than that. It creates a new right. Sexual harassment, wherever it is being done, is an offense, no doubt about it. But when that has been committed at your workplace, it assumes a greater importance. This is a philosophy behind it, I feel. So then what to do? So a new right is created. We think of, probably we'll be thinking of the domestic violence, that act, PWD Act. Well, it created another right for a lady to live in her husband's house, residence. So this was a right which never existed before. And there has been mechanisms mentioned in it, including penal sanctions, to enforce it. Please look into the statute. You don't find a penal statute wherein a new offense like sexual harassment in workplace is created. There are other penal provisions created, but those penal provisions do not include a particular new offense like a sexual harassment that is being done in a workplace. It has been defined. So what is sexual, what acts become sexual harassment, in what circumstances we infer sexual harassment. These are all clearly mentioned in the statute. I am not wishing to read the statute as such. You can just find on a plain reading of the statute that particular things those have been clearly defined there, but it has not created a new offense. So this is one point wherein the statute will have to improve. Of course, that is not a finding fault with the statute. The thing is that once a new right which never existed is being enshrined in a new legislation, there will be practical difficulties felt by as times pass by, and those will have to be taken care of by subsequent amendments. This is how the organization works. This is how it organically develops. So that scope of development is there. So this is my first point which I have to mention here. And secondly, in the formation of the internal compliance committee, I think Madam Indira Ravindran has pointed out that there are many, she has stated that many victims are not coming forth for representing things to the internal compliance committee. And that is for the prime reason that the internal committee is not that much equipped to deal with such situations. It's destined to be so because an internal compliance committee is being constituted from among the institution itself. So whoever that is available in the institution should take an initiative, should be there in the committee. And of course, there are scope for an NGO and all that, but they have to be there in the committee. What I mean, what I point out is that there should be a professional touch to the internal compliance committee, because the action, or rather the business that is being carried out there is not a simple thing, right? You can understand this. They have got every power of a court vested under the Code of Civil Procedure. They can summon witnesses. They can take in evidence. So all these things, all these incidental powers are being exercised by this committee. When these powers are being exercised by this committee, there is need for professionalism. Otherwise, the committee proceedings are likely to be a farce, are likely to suffer from many legal loopholes, which may eventually kill down the spirit, and therefore there is need for a professional touch, at least. This is the second point which I wish to. Now let's please go into section 4. Section 4, how the internal committee ICC is being constituted. Now the presiding officer should be a woman who holds a senior position in the institution, right, in the organization. If there is no such a woman available, then can be somebody who is administratively inferior to the higher boss. So from there the problem starts. Presiding officers, the presiding officers, the presiding member of the internal committee should have a say on what is going on there. If she hails from somebody, we have not developed into a situation wherein in every top brass of every association you find a woman. We have not grown that much. Even now, we don't find much woman in the top brass. So that issue is there. Well, let it be there. And secondly, there should be at least 2 members who are employees and also committed to the cause. How come you test that? How come you test that somebody is committed to the cause? That is too generalized a term. And thirdly, there should be an NGO. There should be an NGO, and of course it says that at least half of the members should be women, right? That's good. That's good. Most welcome. There should be an NGO. The problem is that these NGOs are, to my knowledge, they are not listed statutorily. They are not listed under any schemes that is provided by the government. Well, registrations and all that we may look into, but everybody can float an NGO. So some control should be there. My suggestion is that there should be at least 1 member who had some sort of judicial experience, or rather forensic experience at least. Because the business that is going on there is a solemn one, is a serious one. So we need to give a professional touch. How come it has to be done? That's of course a matter for deliberation, but it's high time that we give a professional touch to this organization called the Internal Compliance Committee or the local committee. If the internal committee is not